Okay, Corey Masuka, Jefferson County Department of Health, Environmental Health Services, Principal Air Pollution Control Engineer of the Air and Radiation Protection Program within Environmental Health Services. And today we're going to talk about permitting, specifically Title V permitting. We have gotten a lot of interest from the communities in Birmingham about permitting, specifically Title V permitting, the largest sources. So today we're going to give you a brief update about the permitting program and specifically how you can participate in the process. The proof is in the permit by Jefferson County Department of Health. This will be broken into two parts, Part 1 and Part 2. Part 1 will address how does the Title V permit help the public to determine which requirements apply to a facility. How does the Title V permit help the public know whether a facility is obeying applicable requirements? What are the characteristics of an effective Title V permit? How can a member of the public participate in the permit development? Why is it important to review and comment on a draft Title V permit? Do I need to be a lawyer or an engineer to review a draft Title V permit? Is it possible to prevent a facility from being built by objecting to the issuance of a Title V permit? Where can I, as the public, locate federal regulations that lay out the basic requirements of the Title V program? Also, how do I obtain government documents that relate to a specific facility or Title V permit? Then we'll talk about recognizing the problem and preparing to review a permit. So often people are unsure of how to find out about whether an industrial facility that pollutes the air in your community is complying with the Clean Air Act. So first, what is Title V? In 1990, the United States Congress passed a law that requires all large sources of air pollution and many smaller sources of hazardous air pollutants to obtain a federally required permit that applies to the day-to-day operation of the facility. And here's an example of a Title V facility here in Jefferson County. Here's an example of a permit. Title V facilities are required to have permits. And here is a major source, also known as Title V, operating permit that lists specific elements of the cover page, including the permittee, location, permit number, issuance date, expiration date, and the individual units within the permit. Here's the descriptor of the individual unit within the permit, including the unit number, again, the company name, source description, operating schedule, and many other essential elements needed for compliance. Within the permit, here are the specific permit provisions that list in detail the exact requirements of the permit that the facility must comply with. This new operating permit program, Title V, provides members of the public with a way to protect local air quality by helping make sure that the air pollution sources are following the law. This program, again, is commonly referred to as the Title V permit program, also known as the Major Source Operating Permit Program. So how does the Title V permit help the public determine which requirements apply to a facility? A Title V permit includes every federally enforceable air pollution requirement that applies to a particular facility. After a Title V permit is issued for a facility, a member of the public, you, who wants to know which air pollution requirements apply to that facility, can simply request to see the Title V permit of the facility. Keep track of pollution levels and whether pollution control equipment is being operated and maintained properly is one of the key objectives of Title V. Title V requires each facility to conduct regular monitoring activities such as performing stack tests and inspections, measuring raw materials and fuel consumption, and keeping records of facility operating conditions and equipment maintenance. Signing on the dotted line. Every 12 months, an official, usually a president or someone as a designee, at each facility must sign a statement certifying whether the facility is in compliance with the requirements of its permit. So it's very important. Informing the public. Compliance certifications and monitoring reports must be sent to the permitting authority and then made available to the public. So what are the characteristics of an effective Title V permit? An effective Title V permit, 1, clearly identifies the requirements that apply to the facility. 2, requires the facility to perform monitoring that assures the public that the facility is complying with permit conditions. And 3, provides the public with the ability to enforce permit conditions. We want to make sure we have practically enforceable conditions in all our Title V permits. How can a member of the public participate in the permit development? The Clean Air Act provides extensive opportunities for the public to participate in the development of a Title V permit. Before a permitting authority can issue a final Title V permit to a facility, the permitting authority must release a draft permit for public review. In addition, the permitting authority must provide the United States Environmental Protection Agency, US EPA, with an opportunity to review and, if necessary, object to each proposed permit. In this case, the permitting authority would be us, the Jefferson County Department of Health. Anyone who participates in the public comment period for a particular draft permit has the right to petition the United States Environmental Protection Agency to object to that permit. If the US EPA does not object to the permit, a petitioner still has a right to take to the US EPA to court for improperly denying the petition. So why is it important to review and comment on a draft Title V permit? Well, if you have concerns about a facility, the importance of reviewing and commenting on the facility's draft Title V permit during the public comment period cannot be overstated. So it's very important, if you have concerns about facilities, to comment during a public comment process. For a Title V permit to serve as an effective tool for enforcing Clean Air Act requirements, it must include all applicable requirements as well as sufficient pollution monitoring. In addition, a permit must be understandable by the public. If you participate in the public comment period for a draft permit, you can advocate for improvements in the draft permit and the facility. On the other hand, if you wait to get involved until the final permit is issued, the only way to remedy a flaw in the permit is to convince the permitting authority to, quote unquote, reopen the permit. Except in unusual circumstances, the permitting authority is unlikely to grant your request to reopen a permit. So do I need to be a lawyer or an engineer to review a draft Title V permit? This question is often asked of the public, and the answer is no. The most important qualification is a desire to protect and improve air quality in your community. Is it possible to prevent the facility from being built by objecting to the issuance of a Title V permit? In most cases, no. A facility is already operating by the time it receives a Title V permit. This is because under federal law, a new facility is not required to apply for a Title V permit until after it has been operating for 12 months. If an existing facility is covered by the Title V permit program, the facility must obtain a Title V permit in order to continue operating. So where can I locate the federal regulations that lay out the basic requirements of the Title V program? The federal regulations that provide the basic requirements of the Title V program are found in 40 CFR Code of Federal Regulations, Part 70, often referred to as simply Part 70. So how do I obtain government documents that relate to a specific facility or a Title V permit? You may be able to obtain these documents by simply requesting them informally, by telephone or in person, from the US EPA or us, the permitting authority. If you are unsuccessful in obtaining government documents informally, you should file a formal request, written request, under your state's open records law. Recognizing the problem. And here I want to talk about several pollutants that emanate from Title V facilities, such as sulfur dioxides, which react with oxides of nitrogen oxides and other substances in the air to form acid rain. Symptoms include wheezing, chest tightness, shortness of breath, basic pulmonary effects. Particulate matter is another pollutant that's emitted from Title V facilities, essentially consisting of small particles of soot, wood smoke, and other compounds in solid or liquid droplet form. PM can also cause respiratory problems, as well as damage to lung tissue and premature death. CO, carbon monoxide. One of the main sources of CO is automobile emissions, but CO is also released by wood stoves and by industrial sources such as boilers and waste incinerators. And the health effects related to CO include visual impairment, reduced work capacity, reduced coordination, poor learning ability, and difficulty in performing complex tasks. Volatile organic compounds combine with oxides of nitrogen oxides in the presence of heat and sunlight to form ground level ozone, which is a very predominant pollutant in the area. Ground level ozone damages lung tissue and can make it difficult to breathe. So I previously mentioned nitrogen oxides linked almost every air pollution problem. Nitrogen oxide emissions result in the formation of ground level ozone, acid rain, coastal water pollution, and reduced visibility. Another separate category of pollutants that are regulated by Title V are hazardous air pollutants or air toxics. The Clean Air Act amendments regulates approximately 170 hazardous air pollutants. Hazardous air pollutants are toxic in small quantities. Health problems related to hazardous air pollutants include cancer, respiratory irritation, nervous system problems, and birth defects. So, is there an air pollution problem in my community? That's a very important question. Many people are not concerned about air quality in their community unless they can actually see the polluted air. Unfortunately, clean air is not necessarily clean air. In fact, many invisible air pollutants pose serious health risk. More than half of all Americans live in places where the air is sometimes unhealthy to breathe. Surprisingly, air quality in places where people go to escape dirt and grime of the city is sometimes worse than air quality in major U.S. cities. So not just talking about confinement to cities, but rural areas also because of pollutant transport. There are several sources available online to check out the air quality in your particular area or region, such as the scorecard, www.scorecard.org. This site, maintained by the Environmental Inc., provides information about hazardous air pollutants according to the zip code. It also provides information about criteria pollutants in each state. Another source is going to www.epa.gov/air now. This site offers real-time ground level ozone information for many parts of the country and health information about other pollutants. Another site where it allows you to compare air quality in your region with other regions, including counties and states, is www.epa.gov/aircompare/index.htm. Very important site if you want to see how your air quality compares to air quality in other states and locals. Additionally, we have a real-time site here, a site that allows you to look at real-time data in Jefferson County, and this is the particular site, vortex.nsst.uh.edu/impact BHM. Again, this site allows you to see real-time air quality data in Jefferson County. So, preparing to review a permit, very important question. What are the essential elements of the permitting process? Well, first, the facility owner is required to submit a permit application. Based upon the information provided in the permit application, the permitting authority develops a draft permit. The draft permit is then released to the public for a 30-day public comment period. Any comments must be submitted to the permitting authority by the end of the 30-day period. So it's very important, again, if you have concerns about a permit, to comment during the 30-day public comment period. And later I'm going to talk about mechanisms of how we advertise draft permits. During a public comment period, you can request a public hearing in addition to submitting written comments. Written comments must be considered by the permitting authority whether or not a public hearing is held. After weighing any public comments, the permitting authority will decide whether to make changes in the draft permit. Before the final permit is issued, the permitting authority must submit the draft permit to the United States Environmental Protection Agency for a 45-day review period. Note that in some states, the U.S. EPA's 45-day review period runs concurrently with the 30-day public comment period, and that is the case here. Our public comment period and 45-day review period do run concurrently. Unless we receive comments during the public comment period, then they will run sequentially. When the draft permit is submitted to the U.S. EPA, it becomes a proposed permit. So it's no longer a draft permit. It is a proposed permit. A proposed permit becomes final if the U.S. EPA does not object to it. If the U.S. EPA does nothing, the proposed permit will become final exactly as it was written by the permitting authority. If the U.S. EPA rejects a proposed permit, the permitting authority must either 1, deny the permit, or 2, revise and resubmit the permit to the U.S. EPA within 90 days of the U.S. EPA's rejection notice. If the permitting authority misses the 90-day deadline, the permitting authority loses control over the permit. U.S. EPA is then required to either deny or rewrite the permit. That rarely happens, but again, that's a mechanism for ensuring that a proper permit is issued for a facility. If the U.S. EPA fails to reject a proposed permit, any member of the public who submitted comments during the public comment period, again, this is very important, you have to submit comments during the public comment period, you may petition the United States Environmental Protection Agency administrator to reject the permit. Such a petition must be filed within 60 days after the U.S. EPA's 45-day review period ends. After receiving a petition, the U.S. EPA has 60 days to respond. So again, if you want to submit a petition after the permit is issued, you would have had to have commented during the 30-day public comment period. If the U.S. EPA denies a petition, the petitioner may bring a lawsuit against the U.S. EPA challenging the denial in the Federal Court of Appeals where the facility is located. Moreover, anyone who participated in the public comment period can challenge a final permit by bringing suit against the permitting authority in state court. When were Title V permit applications due for existing sources? Title V permit applications were due for existing sources 1 year after the effective date of the Title V program approved in your area. And I think our program was approved approximately in 1995. After the application deadline expires, any Title V facility operating with a permit application on file with the permitting authority is violating the Clean Air Act. Any new facility must apply for a Title V permit within 12 months after beginning to operate. Note that a new facility must comply with the Clean Air Act requirements during the first 12 months of operation. Now, let me make a side note here. We're a little bit more stringent. We typically require a new Title V facility here in Jefferson County to have a permit first. So again, while this is allowed under Part 70, we typically require a new Title V facility to first have in hand a permit. So what happens if a facility misses the permit application deadline or fails to submit a complete application before the deadline? If a Title V permit applicant submits a complete application by the applicable deadline, the applicant receives a permit application shield. This means that while the permitting authority is processing the permit application, the facility may continue to operate. If a facility owner fails to file a complete application by the application deadline, the facility is not protected by the permit application shield and is operating in violation of the Clean Air Act. It rarely happens, but again, if they fail to submit an application by the deadline, then they are not protected under federal law. Unless the permitting authority determines that an application is incomplete within 60 days after it is submitted by the applicant, the permit application is automatically deemed to be complete and the facility is protected by the permit application shield. If the permitting authority determines that an application is incomplete, it notifies the facility in writing and requests additional information. And that's what happens a lot of times. We get applications that are incomplete and we need to request additional information so that we can determine what's needed to draft a complete permit for the facility. If a facility's permit application is deemed complete, can the permitting authority still request additional information? The answer is yes. Even after an application is deemed complete, the permitting authority may request additional information if it is needed to process the application. The permitting authority must request such information in writing and set a reasonable deadline for the applicant to respond. If the applicant misses the deadline, the facility is no longer protected by the permit application shield. How much time does the permitting authority have to consider a permit application? Once the Title V permit program is in full swing after the first 3 years of operation in an area, permitting authorities will be required to take final action on each permit application within 18 months after submittal. Final action refers to the permitting authority's decision to issue or to deny a permit. How do I know when the public comment period begins for a permit that I'm interested in? This is a very important issue that has been brought to our attention by the various citizens of affected neighborhoods. Once the permitting authority develops a draft permit, the permit must be released for public comment. The permitting authority must give the public at least 30 days to submit comments on the draft permit. The public comment period begins when the permitting authority publishes in a public notice announcing that the draft permit is available for public review. According to federal regulations, the notice must be published in a newspaper of general circulation in the area where the source is located or in a state publication designed to give general public notice. In our case, we typically publish public notices in the Birmingham News. However, as of late, with citizens expressing concerns about limited availability, limited knowledge of public notices being published in the newspaper, we now publish draft permits online on our website at www.jch.org. We also tend to try to interact with communities by informing these neighborhood groups of the drafting of a permit and giving them the permit public comment periods and other mechanisms to, again, inform the community outside of the public notice and the permit that a permit is up for public comment. Some permitting authorities publish a newspaper notice, usually in the legal section, and a notice in a state publication. The notice must include, at a minimum, the name of the facility, the name and address of the permittee, the name and address of the permitting authority, activities covered by the draft permit, any emissions change involved in the permit action, who to contact for information, how to get a copy of the draft permit and supporting materials, how to submit comments, time and place of any hearing already scheduled, and how to request a hearing if a hearing is not already scheduled. Again, an important question that's been raised by many citizens is, how do I know when the public period begins for a permit that they're interested in? Each permitting agency creates its own format for public notice. Regardless of the format, all information listed above must be included in the public notice. If the public notice for a draft permit that you're reviewing does not include all the required information, make a note of the missing information. You can identify and comment on problems with the public notice and any comments you submit during the public comment period on the draft permit. In addition to publishing a notice as described above, federal regulations require the permitting agency to mail the public notice to any person who requests to be on a mailing list. So if you want to know about permits in your area, submit a request to us and we'll put you on a mailing list. If you already know which draft permits you wish to review, then you can request to be on a mailing list for notification when those draft permits are released for public comment. If you have not yet decided which draft permits you wish to review, or if you plan to review a large number of draft permits, then you can find out where your permitting authority publishes public notices. You can also require to be placed on a mailing list for every Title V facility in your area. Make sure that you know exactly when the deadline is for submitting comments. Except in rare circumstances, if you miss the deadline for submitting comments, you lose your right to petition the U.S. EPA to veto the permit, as I stated earlier. In addition, you use your right to challenge the issuance of the permit in state and federal court. Because of the importance of the deadline, you should get proof when you submit your comments that they are submitted on time. If you hand deliver your comments, ask the person who accepts the comments to sign and date a statement that says or indicates they received the comments prior to the end of the public comment period. If you send the comments by overnight mail, save the date receipt. If you send comments by regular mail, there generally is no guarantee that the permitting authority will receive them before the end of the comment period, and you will not have a record to rely upon. Will the permitting authority respond to my comments? While federal regulations do not require the permitting authority to provide a written response to your comment, many state laws do require such a response. Even if the permitting authority does not modify the draft permit in response to your comments will form the basis for your petition, should you decide to the EPA requesting that the agency veto the permit. If the permitting authority made substantial changes to the draft permit after the public comment period and does not release the revised permit for a new public comment period, you can argue that the public must be given a new opportunity to review the draft permit because it's changed before the permit is submitted to the US EPA for review. If I want a public hearing on a draft permit, when and how do I request one? If you want a public hearing, you must request it during the applicable public comment period. The permitting authority must provide information about how to request a public hearing in the public notice announcing the availability of the draft permit for public review. The federal regulations 40 CFR 70 says that the permitting authority must provide an opportunity for public comment and a hearing on draft permits. Some states interpret this phrase as requiring the permitting authority to hold a public hearing whenever one is properly requested during a public comment period. Other states interpret this phrase more narrowly. Main thing here is, yes, you may request a public hearing. However, the agency permitting authority will be the determiner of whether to grant that public hearing. If you want a public hearing, your best strategy is to determine the relevant standard under state law. If state law requires you to satisfy a particular standard, make sure your request includes whatever facts, concerns, arguments you have to show how you have met the standard. Be sure to assert that the permitting authority is required to hold a hearing because your comments satisfy the state law standard for when a public hearing is required. If the permitting authority denies your request for a public hearing, consider raising this issue with the US EPA. The deadline for requesting a hearing is usually the same as the deadline for submitting comments during the public comment period. This information should be included in the public notice. If it is not, you can call the contact person listed in the public notice and ask. The permitting authority must give notice of any public hearing at least 30 days in advance of such hearing. When does US EPA's review period begin and what does it involve? When the permitting authority is satisfied with the draft permit, it must submit the draft permit to the regional U.S. EPA office for a 45-day review period. Again, at this point, as I mentioned earlier, it's called a proposed permit. At the time the draft permit is submitted, again, it becomes a proposed permit. Note that some states' U.S. EPA agreed to allow its 45-day review period to run concurrently with the 30-day public comment period. So again, as I indicated earlier, our public comment period runs concurrently with EPA's 45-day review period, assuming we do not receive any comments from the public during the 30-day public comment period. During the 45-day review period, the U.S. EPA must object to proposed permit if the agency determines that the proposed permit does not comply with federal laws or regulations. In addition, the U.S. EPA can choose to object to a proposed permit if the permitting authority does not provide the U.S. EPA with sufficient supporting information to allow for meaningful U.S. EPA review, or if the permitting authority fails to follow the right procedures for public participation. If the U.S. EPA does not object to a permit, the permitting authority may issue it as a final permit. While every permit must be submitted to the U.S. EPA for a 45-day review period, the U.S. EPA is not required to review every proposed permit. In fact, even if the U.S. EPA decides not to review a proposed permit, the permitting authority can issue it as a final permit at the end of the 45-day U.S. EPA review period. Each regional U.S. EPA office has its own policy on selecting permits to review, but the U.S. EPA suggested a target of reviewing at least 10% of all permits proposed for facilities in each of the U.S. EPA's 10 regions. The U.S. EPA is most likely to review proposed permits for very large or controversial facilities. So what happens if the U.S. EPA objects to a permit? If the U.S. EPA chooses to object to a permit, it must give the permitting authority a written explanation for the objection and give the permitting authority at least 90 days to submit a revised version of the proposed permit to the U.S. EPA. If the permitting authority misses the 90-day deadline, the U.S. EPA will either deny the permit or develop a new permit for the facility independent of state or local permitting authorities. When does a permit become final? If the U.S. EPA does not object to the final proposed permit, the permitting authority may issue it as a final permit at the conclusion of the U.S. EPA's 45-day review period. In some cases, the U.S. EPA will waive its right to a full 45-day review period. And following here is a chart showing, again, how the public can get involved in the public comment process. Again, at the top, see draft permit release for public comment period. Following that is review facility files, permit application and draft. Again, the public does have a right to review any facility file information, any permit application information, and the draft permit. Then during that 30 days, submit comments to the permitting authority. If comments are received, it may take several months. The permitting authority considers public comments and forwards a proposed permit to EPA. Next, EPA receives the proposed permit and the 45-day review period begins. Going down, following EPA's review permit, the public has 60 days to petition the EPA to object the permit. Now also notice here the block that says EPA receives proposed permit and 45-day review period. If EPA objects, as I indicated earlier, the permitting authority must revise and so resubmit the permit to the EPA within 90 days. So why should I get a copy of a Title V permit application for a facility that I'm interested in? Again, this is part of preparing to review the permit. Important information provided in the facility's permit application will help you to develop effective comments on the facility's draft permit. Getting the application prior to the start of the public comment period will give you a heads up in developing your comments in the draft permit. So a lot of important information about the facilities is in the permit application. However, the department does have the discretion to make sure any confidential business information is redacted from the application prior to review by the public or third party. What information should I look for when I review a facility file? Agency files typically contain enforcement information, enforcement history, including records of inspections, official notices of violations, and administrative consent orders. In addition, they contain reports that the facility has submitted, letters exchanged between the facility and the permitting authority, monitoring protocols, and stack test results. By reviewing the file, you might discover that the facility has a pre-construction permit or that the facility has had trouble complying with certain regulations. This most certainly will be relevant to your review of the draft permit. Don't be discouraged, however, if you have a difficult time understanding the more technical reports and monitoring data. The most important aspect of the file review is to identify the following: the type of monitoring information that the facility is already submitting on a regular basis, any compliance schedules or consent orders, any permits issued to the facility other than the Title V permit, such as construction permits, any disputes over conditions included in the draft Title V permit, and any evidence that the facility is violating a legal requirement. What do I do if I want to see lots of files? If you plan to review a large number of Title V permits, you should go ahead and request access to all facility files that you might be interested in, including permit applications, inspection and monitoring reports, compliance plans, and enforcement actions. In your request, explain that you will not be able to review all of those files at once, but would like to establish a schedule so you can review the information at a reasonable pace. Make sure that you request access rather than copies of these documents. Typically, the agency will allow you to review the documents in the permit files at their office. As you review the files, obtain a copy of any document that seems relevant. How much will it cost to copy what I need? Many permitting authorities will waive fees for individuals or organizations that wish to use information to benefit the public. Single copies of the draft permit and other associated documents, such as the application, may be obtained free of charge. What should I do if I run into problems of getting to see or copying files? Document any problems that you have in obtaining a draft permit, a permit application, or any other supporting documentation necessary for you to effectively review a draft permit. A permit cannot be issued if the public is not provided a reasonable opportunity to review the draft permit. You can describe any problems that you encounter in the comments that you submit during the public comment period. If you are unable to resolve a problem with the permitting authority, ask your regional U.S. EPA offices for assistance. So in summary, again, part one, Title V permits include all applicable requirements and sufficient monitoring that must be adhered to. Members of the public can participate in the public comment period and the permit development process during the draft permit public comment period by submitting comments and or requesting a public hearing. Members of the public may review the draft permit and associated applications and other materials. And finally, the U.S. EPA reviews proposed permits.